Mrs. Roberts, can you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, Original Jurisdiction, Case Management Conference in AGOJ number 1 of 2021 between Ellis Richards, Medical Benefits Board, Spencer Thomas, and others, and the state of Trinidad and Tobago. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Witt.
Good morning, respectively, good afternoon, everyone.
And Mr. Justice Anderson.
Good day, everybody.
May we have the appearances, please? Thank you.
Yes, thank you, Your Honours. I appear, Simon Davenport, together with Dr. Kenny Anthony, Mr. Robert Strang, Mr. Gregory Pantin, Professor Matthew Happold, George Kernan, and Mr. Miguel Vasquez.
Your Honour, should it please you, Mrs. Deborah Peake leads me tomorrow Tulsi for the state of Trinidad and Tobago, and we are instructed by Mr. Brent James and Ms. Carissa Singh.
Okay, good morning again, Council, and thank you for your appearance today. Mr. Davenport,
Your Honour,
I trust that you would have received the court's communication that was sent yesterday. I know that it may have come just about the time you would have prepared and or sent your own views as to how best we could proceed this morning, today. But I haven't heard or seen any response from your side on the court's intimations.
Your Honour, you're right about that, and I apologise if we could have made it clearer for Your Honours coming into court today, and we won't make that mistake again. Our position is, as per the skeleton argument, we very much acknowledge with thanks the very helpful note that we received from Your Honours yesterday. We of course, received that prior to Your Honour getting our skeleton argument, and I think there was nothing to intimate to you that there would have been a skeleton argument coming. So it's our habit to do it, but I know it's not the court's habit to expect it. But if I can make it clear today that if you will give me but a few moments, I would like to persuade Your Honours of the virtue of not proceeding to attempt to define a preliminary issue, and that at the end of the day, it's not going to make really very much difference to the fact of there being a trial or the claims being determined by this court. So yes. It won't take me long to outline that. And therefore, if you were to be with us in respect of that, it might persuade Your Honours to reconsider whether or not to go down the route of preliminary issues. And if that was the case, we could make progress on that limb. And then I have some small matters to discuss with the court in respect of the other issues, namely management of the claimants and any other directions. None of that will take me long.
Yes, go ahead.
I'm grateful. I think, as we all recognise, and it's explicit within the last email that you would have received from Ms. Peake and her junior, that it's only where there are true knockout blows or dispositive points that any court will be interested in preliminary issues. And so the first and perhaps the most important point that I can address Your Honours on this morning is that resolving the Article 30 jurisdiction will hardly affect the claims at all and will not by any means prevent a trial of the action, because of the 4 claims pleaded, the defendant's Article 30 objection only covers the second claim. and only one limb of the first. And I'll show you how that is the case.
No.
So-
before you show me that,
Of course.
if that Article 30, the Chapter 3 point, is addressed and is resolved in your favor, then of course the rest of the matters would have to be dealt with.
Correct.
If they are resolved in favor of the defendants, then yes, there is some aspect or some aspects of the case that would still have to be resolved, but one would have, don't you agree, that one would have removed from the rest of the case a significant chunk?
I would. Sorry.
Yeah, go ahead.
No, not at all. I think first, the most important point today I can and say to you is that we're ultimately agnostic, because we want to do what is right for the best case management of this matter. What we're concerned about is that it might not resolve really very much at all. I would agree that it would resolve the Article 30 point, but it would not deal with the claims, and all of the claims bar one would survive, and it wouldn't affect the value of the claims at all. Moreover, we conceive that there really will be some necessary factual determination, so that if you were to proceed, you would have to proceed upon the basis that the factual assertions in our originating proceedings were correct, which is likely to lead to the possibility of having to do this twice, namely that you might come to the conclusion that there is arguability in respect of the pleaded claims because you are bound to accept the facts as we assert them, but that once you've found facts, your position might change one way or the other. So that's our practical concern, is that whilst it's driven by very much the best intentions of dealing with what looks like a legal point and therefore compartmentable, it might really not turn out that way. And that's the reason for the schedule to the skeleton argument, was that these are well-known cases, of course, and the well-known shared principles. But so often it seems like a good idea when one embarks on the journey, even on a point of law, but very often it doesn't turn out that way. So our concern is that we will just delay matters, have a fairly sizable hearing, but ultimately it might not advance matters very much. And if it's not determinative of things completely, then our position would be that your court's resources are best deployed by hearing this matter once and once only.
Yes.
Mr. Davenport, I must confess, I'm not sure I understand what you're saying.
Yep. Well, what I'm trying to say.
No. Let me explain the difficulty I'm having. Are you not of the view that the actions being brought by your clients are grounded primarily in Chapter 3 of the Revised Treaty? I know that there is a claim related to Article 184,
yeah,
but it seems to me that most of the substance of the claim that you're raising in respect of discrimination are grounded in Chapter 3. Am I right or wrong?
Well, I think you're partly right, Your Honour. There are 4 claims. The first claim is grounded in both Chapter 3 and in Article 184. And the 4th claim, which is restrictions in the regulatory scheme, is grounded in Article 184 alone. So those two ultimately are not going to be affected by a determination of Article 30. I accept that the second claim is completely covered by Article 30, so that that would fall away if it was determined the other way. And the third claim, which is that the regulatory scheme included discriminatory restrictions on the rights to provide and receive cross-border services, triggering Articles 37 and 38, we say nonetheless Article 30 does not cover that, because those articles, that is Articles 37 and 38, dictate how governments are to regulate cross-border services and expressly require governments to remove regulatory restrictions.
Well, will you concede, Mr. Davenport, that that itself is a matter for interpretation?
Yeah.
Because Article 30, paragraph 2, speaks in terms of actions in a member state being excluded from the operation of this chapter. And the articles to which you just drew our attention, including
Yes.
37, 38, are they not in that chapter?
They are. I would accept, Your Honour, that they are.
Okay, so is it not a matter then of legal interpretation by us as to whether the claims which are based on 37 and 38 are implicated in the exemption in Article 30, paragraph 2?
I accept that, but it's so obvious in our respectful submission that Article 37 and 38 really wouldn't have a purpose if they were covered by.
Well, you're making the legal argument now, but
I accept that.
What I'm trying to get from you is whether, as the President said, a resolution of Article 30, paragraph 2 would not have consequences for all of your claims which are based in Chapter 3.
I think it wouldn't have any consequence to Claim 4. It would not have any practical consequence to Claim 1. Arguably, it would or would not, depending on whether I was right about what I've just said to Your Honour, cover Claim 3, and I accept that Claim 2 goes. And I suspect that what you really require is some factual context. Now, I can't rehearse that ad nauseam. That's as good as it gets for the purposes of today, because I understand that I'm sure some progress would be made by going down this route. It's just not very dispositive and not very determinative. That's really, Your Honour, the point that I wanted to make to this court.
I don't know if you've seen the submissions for use of a general word by the defendant this morning, but my understanding, and I've just had a brief glance at it, is that they're also asking for the issues related to Article 184 to be also tried as a preliminary issue. If that was to be the case, would you then concede that the trial of these matters would have implications for all of the claims that you're making?
Well, I know the convenient answer would be yes, but I'm afraid the plain answer must be no, because I suspect a little longer in front of Your Honour, and you would realise that those are surely factual questions which are being asked to be determined. They're not pure matters of law. It makes a number of twice it makes the assertion that the actions have to be contemplated. Now, the actions are obviously matters of fact, but both effects, as in intentions, as well as effects, so direct as well as indirect consequences, and therefore indirect discrimination, are obviously matters which are highly factually sensitive. Now, that would be a roadblock of their proposed items B and C. So I suspect it gives the game away, because they know that that's in their way of the submissions that I've made in relation to why there is really absolutely no dispositive value worth having to the preliminary issue at all. And so I think that just a few moments more spent at this stage will save a great deal of time later. And a great deal of expense and worry for a large number of citizens, who are wanting to get on with this matter. Yeah. So that's our position, really, is that it's probably best avoided, although we fully recognise and agree with the idea and the impulse that if time can be saved by real preliminary issues, then it should be. Now, the fact that they weren't really able to identify it, and then it fell to this court doing its excellent best to identify it prior to getting our written submissions, indicates that the difficulty in grappling with it. And secondly, as I've just said, the fact that they then tried to somehow deal with Article 184 because they recognise that otherwise they're left with a trial, shows the sort of desperate position that they find themselves in, and the fact that they're having to import obviously factual matters for the purposes of determination. And the giveaway, Your Honour and Mr. Justice Anderson, is that they're talking about limits to disclosure, or disclosure of documents, i.e. facts. So the idea that they're even dealing with disclosure means that there is a factual context to the positions that they want to put before this court. That's really my answer to.
But I just engage you one last stanza of this conversation from my point at this point. I think you made a reference to certain common law decisions which discourage the holding of hearings to determine preliminary matters. And, you know, those points are made in very emphatic terms, as obviously you indicate. However, that is not necessarily the case in international law, is it? Where we are now. Is it not customary for international tribunals to deal sometimes separate hearings with preliminary points rather than having them all discussed with the merits of the case?
Well, I accept that in some contexts that might be the case, but I don't think that really can be the case where this court has two jurisdictions, one being an originating jurisdiction, because it is sitting in an originating jurisdiction and determining, as it were, trial matters. So whilst I'm positively encouraging that if we found anything that is a preliminary issue, that we deal with it, I'm just deeply, deeply sceptical about that we will be doing anything than maybe some further argument about Article 30. So I might be wrong, and the whole team with me entirely wrong about this, but we're very much of that view. That's the reason why it's been so very difficult for the state to be able to identify what is a preliminary issue. And they certainly didn't do it in their statement that they gave to this court just a few days ago.
I understand you, Mr. Davenport. I was just making a more general point that, as I said, I think it's fairly customary for international tribunals to deal with jurisdictional issues as distinct from the merits. And that is the position, I believe, certainly with the International Court of Justice, that in every case, almost, they have a separate hearing on the jurisdictional points and then on the merits if they get there.
Yeah, I fully accept that. I mean, I can't rehearse, and I don't want to overstate it, because if we were wrong, we would only be too delighted to try and foreshorten matters or make matters further down the line easier. But we're only trying to help with case management this court, and we do it with the greatest respect. And I don't know any better, certainly don't know any better than Your Honours how best your court will work. And so I will very much defer to this court in any such utterances. It's just that when we look at, as it were, what we had before us when we did our skeleton argument, which was not this court's note, but was the statements which had been made by the other side, we couldn't discern that they even wanted a preliminary issue, let alone what it was. And so we addressed it on that basis.
Thank you, sir.
Thank you.
Okay, thank you. Mrs. Peake, do you have a short response?
Much obliged, Your Honour. I haven't heard anything that fell from my learned friend's lips that should cause the court to depart from the position as set out in the note, that it would be just inconvenient to have these issues of law determined, because as we understand the claim, it is essentially based on a Part 3 complaint, which could be knocked out on a proper interpretation of Article 30 we see. And the second, I heard my learned friend talk about 4 aspects of the claim, but we really see it as 2 if we locate it within the articles of the treaty. And the second is the 184 article point. So what we've sought to do in the note that we have sent in response to the court's note is to deal with both issues of law as a question of construction. And therefore it assumes, as the court's note had indicated, the accuracy or the truth of what the claimants assert in the originating application. So there is no issue that needs to be resolved. And therefore we proceed to determine the court's jurisdiction based on the construction of the relevant articles which have been invoked. And we think even, whether it is, as Justice Anderson has suggested, that in international courts, the view is different from domestic courts on preliminary issues. Even looking at the authorities that Learned Friend has annexed to their skeleton argument, I think having formulated the points of law as we have, and as the court has sought to do, and assuming the truth of the allegations and the claim, we fall within the exceptions to determining, or the lack of wisdom of sometimes the courts see in determining preliminary points. We fall squarely within the thinking that it is appropriate in certain circumstances and dispositive if you can identify and determine preliminary issues. And we say, if you look at the way in which we have formulated it, we think that if the court agrees with us on the interpretation of Article 30, then that aspect of the claim falls away. I think Mr. Davenport has accepted that is the majority of the claim, in which case all that is left is 184. And we feel, assuming, again, the accuracy of what they've contended in the originating application, and assuming that the article has the broad reach that my learned friends contend for, we still see that they do not fall within a breach or an allegation of a breach of that article. So we say for all of those reasons, this is an appropriate case, and we're not talking about using a lot of time and resources of the court in identifying the issues, having the court the benefit of submissions on those issues on a short hearing if necessary. In relation to my learned friend's suggestion that disclosure connotes facts, the reality is that originally they contended that there were no non-nationals who benefited from the BAT rescue. In fact, we have put before the court that there were 13 policyholders, and they've come back in their reply and said, well, it's de minimis. So in a sense, they have accepted, because of course they were not in a position to know at the beginning whether there were national or non-national or resident or non-resident policyholders who benefited. But they say even if there were, it is de minimis. And we say all we want to do is produce to the court the 13 policies and the deeds of assignment to confirm it. And because of the confidentiality issues, we will give them the policy numbers and the nationality, the status of the individuals. And of course, the court, when it sees the documents, which we will disclose to the court under confidential cover, can decide whether the court thinks it appropriate to give them any of it in a redacted form. So those would be our respectful submissions. We would commend to the court the identification of preliminary issues to be determined shortly, and we are prepared to assist further as to how those issues could be crisply and concisely identified.
Not to get into the weeds, with your permission, President.
Yes, go ahead.
May I ask, you mentioned, Mrs. Speak, the 13 policyholders. But in your documents you sent to us suggesting that there was not discrimination on the basis of nationality only, you also pointed to a donation of some kind of 86 million, I think, I remember, and then 1,072 policies. Could you just for 1 second elaborate on that, particularly the 1,072 policies? What was that?
That is in relation to CLICO, because even though my learned friends describe it as a BAT rescue plan, in fact, the policy of the government was to rescue CLICO and BAT policyholders. So that number that you want to refer to refers to the CLICO policyholders. In fact, there were not many policies at all in relation to BAT. And that is how we end up with a much smaller number of non-nationals. In the case of CLICO, the number of non-nationals was actually 1,072.
Ah, I see. And in relation to BAT, the number of non-Trini policyholders was 13, is it?
Yes, correct.
Thank you. Thank you, President.
Yes. Mrs. Peak, first of all, thank you for the alteration of Government of Trinidad and Tobago to State of Trinidad and Tobago. On your second and third suggested preliminary points, you speak there, and Mr. Davenport referred to it, about the actions of the state of Trinidad and Tobago in each of them, isn't it the case that there is still controversy? There is still not, the parties are not ad idem on what were or what were not the actions of the state of Trinidad and Tobago?
Well, I think we've covered that by what's in the chapeau, which in fact was the court chapeau, which is assuming the truth of the matters pleaded by the claimants in the originating application. So that gets around any disputes or arguments as to exactly what the actions were.
You say assuming that the actions of the state of Trinidad and Tobago fall within the scope of Chapter 3. Did the state of Trinidad and Tobago in its actions in the CLF bailout discriminate on the grounds of nationality? That's the way in which you've suggested a formulation of the discrimination point. Isn't that going to take us into the realm of having to decide factually what were or what were not the actions of the state of Trinidad and Tobago?
And we say no because the chapeau to B and C is assuming, for the sake of argument, the truth of the matters pleaded by the claimants in the originating application. So that assumption governs the way that we would look at those questions which follow.
I understand. And that's the second point. The last one is the same thing, assuming for the sake of argument the truth. I see the chapeau covers A, B, and C.
That is correct.
But you would confess or concede, I hope, Mrs. Speak, that whereas you could comfortably house the first two issues under the umbrella of jurisdictional points, Article 30, Article 7. The third area that you wish for us to look at as a preliminary matter, Article 184, that doesn't easily fit under the rubric of jurisdictional issues. Would you concede that?
Your Honor, I don't with respect conceive that, because it seems to me whether we go the route of 184 or we go the route of 36, 37, 38, it still has to be located in Article 7. And Article 7 is making the point that assuming it falls within the scope of the treaty, that is, assuming 184 bites, has there been discrimination by the state on the grounds of nationality only? That is the only thing that is prohibited by 7. So 7 is not freestanding. 184 is not freestanding, at least in the context of this claim, because as we've sought to make clear, and my learned friends made clear in the note that they circulated yesterday, this is a discrimination claim. So discrimination by way of the 36, 37, 38 route, Chapter 3, or discrimination by way of the 184 Chapter 8 route, it still comes back to seeing whether it falls within Article 7. So assuming it is within the scope of application of the treaty, tick that box in respect of 36, 37, 38, and 184. The question is, assuming their facts, has there been discrimination on the grounds of nationality only within the meaning of Article 7? And that is a question of law.
Could you just remind me, what article precisely we're talking about? 184?
1J.
1J.
Yes.
Okay. Now, could there be an action brought in relation to 184 1J without the implication of Article 7?
Well, not in the context of this case. Not in the context of this case. Because,
Why?
well, first of all, that's how you read what's in the originating application. And can I just take you to paragraph 5.3 of the note which was circulated yesterday, where my learned friends summarized the 3 main limbs of the claim. And in 3 they say, a claim that the defendant, in excluding the customers of BA International from a scheme to provide redress to the customers of BA Trinidad, a scheme falling under 184 1G of the Revised Treaty, thus discriminated against the customers of BA International in breach of Article 7 and failed to provide adequate redress within the meaning of Article 184(1)(g). So they have crystallized their claim. As we go along, you will see the reply crystallizes it much clearer than in the originating application. And this, we think, which is the most recent iteration of their claim, makes it even clearer. So that's why we say, sorry.
That conjunction there, and, is it conjunctive or disjunctive? They discriminated against the customers of BA International in breach of Article 7. Because you see, when I first read the originating application, which is the principal document that sets out what the claimant's claim is, I did not at that time appreciate the Article 184(1) point as bound up with discrimination. And it is only when I saw this brief that was sent yesterday that it occurred to me that that either may be the view or that there is a further view that it also is bound up with discrimination.
Well, we have always understood the claim to be a claim in discrimination by different routes. And that is why the way we understand the claim, as confirmed by the note yesterday, is that it is either the route is either the Article 3 route or the Article 184 route. And
Chapter
if you
3
look at,
you mean the
sorry,
chapter 3?
Chapter 3, Article 30, or 184, Chapter 8. And if you look at 72 of the originating application, of course, the language is not always the clearest, but here is what they say. Further, the defendant's failure to include BA International in the Trinidad and Tobago regulatory scheme amounted to a failure to take appropriate measures to promote the interests of the consumers of the insurance services provided by BA International, including through the provision of adequate and effective redress contrary to Article 184(1)(g) of the treaty. So it's always in the context of the differential treatment they allege in relation to non-nationals.
No, with respect, I didn't see that as being grounded in a discriminatory approach. It simply says they failed to take appropriate measures to promote the interests of the claimants as consumers of insurance services, including through the provision of adequate and effective redress. So that I don't think we need to go on and on about this. The point is that, and Mr. Davenport, of course, is better able than either of us to indicate what exactly his claimants are claiming. But as I read the 184(1) point, it struck me as certainly initially in the claim not being rooted in discrimination as much as in simply a failure, as the treaty says, to take or to provide adequate and effective redress for consumers. But let's get back to the issue of the identification of the issues. I think, and the court certainly, as you would have seen from what we had sent out yesterday, are of the view, and I think I can say now that Mr. Davenport has not persuaded me that we ought not to try separately the issue of the Chapter 3 point. Is it your view that if the Chapter 3 point is decided in your favor, that because of the introductory words of Article 7, that the discrimination, that the Article 7 point also, and that's the second limb of the way in which the point is stated, the consequences. Is it your view that if that Article 30, Chapter 3 point is decided in your favor, that the Article 7 point also goes away?
Yes, because if at its heart the claim is a discrimination claim grounded in Articles 36, 37, 38, and we are right, then it is not within the scope of application of the treaty, and then Article 7 doesn't bite.
Yes, but
So-
at the same time, if it's not, if it doesn't go in your favor, so that it is within the scope of the treaty, then I think your next argument is that it's not within the scope of Article 7. So that, resolving the Article 32 in your favor would admittedly, on a preliminary reading, seem to take care of the Article 7 point. However, if it is not resolved in your favor, then the Article 7 point stands. And at that point, it seems to me is where you want us to consider that second issue, which is to say that any discrimination alleged was not on the basis of nationality only. Am I right?
That is correct. And we say that can be shortly resolved by the court looking at the 13 policies and the information relating to the policyholders. So that's not a matter that requires evidence to be elicited and cross-examination and so on. That's a matter of documentary evidence. So if we fail on the construction of Article 30, then we still succeed on the Article 7 point.
Or you could still succeed.
Well, we say yes, we can still succeed.
Yeah, but I would have thought, though, that the issue, if we were to go in that direction, would have to be tried as a matter of law, because it may be that as a matter of law, the case does not come within Article 7 because there was no discrimination on the basis of nationality only. However, if we were to decide that, no, it could possibly come within Article 7, then we would have to go further then to look at issues of fact, possibly. And at that stage, I don't know if the floodgates would be open, but we're in a new environment altogether. So my question then is, would it not be advisable to restrict, if we were to go there, the trial of the preliminary point concerning Article 7 to the ground of law only, so that if you succeed as a matter of law, it knocks out the claim. But if you fail as a matter of law, then the issues of facts that Mr. Davenport was alluding to could possibly come in. Am I making sense?
I'm not sure if I fully understand. So, assuming we fail on the Article 30 point, as a question of law, we determine the Article 7 point. That is, whether you can succeed on the ground of discrimination because of nationality only.
Right.
Because that's the only way Article 7 will bite. If you are able to establish that based on what you have alleged in your originating application, there was discrimination on the grounds of nationality only. Now, what we say in relation to that is that yes, we can deal with it in that way, but it seems to me it's a very short path to lead us to establishing it by virtue of looking at the policies. So to say that we will stop, the trial of the preliminary issue there, and then depending on how the court rules, go on to determine whether it will, allow these policies to be disclosed and the court examine it, in our respectful submission, doesn't seem to be a sensible way to proceed.
I'll give you an example of what I have in mind. I don't want to go too far because I'm not on either side, obviously, of this dispute. But you might recall that Mr. Davenport said that what you have done in relation to BAT and the 13th policy is a matter de minimis. So, if as a matter of law, you could say that obviously the treaty says that discrimination has to be on the basis of nationality only for there to be a successful claim. But, as a matter of law here, because the departure from discrimination on the basis of nationality only was so very minor, was so trifling, it doesn't apply on the facts here. And if we were to get to that stage, wouldn't we then need to go into the more factual aspects of the case? In other words, okay, you have 13 policyholders. What if it was just one policyholder that was non-Trini, would the notion of discrimination on the basis of nationality only be able to save the defendant in that situation? Is not Mr. Davenport's point that this is a de minimis situation?
Frankly, Your Honor, I don't understand the minimis in the context of nationality only. If we have a client base of 52,000 and it turns out that only 13 of them are non-nationals, you can't increase the number of non-nationals to make Mr. Davenport happy. That's what our client base shows. And we say we did not discriminate in not extending the bailout to non-nationals. That is the extent of our non-national policyholder list. So whether he thinks it's a high enough number or not, in our respectful submission, he cannot succeed on the ground of discrimination on the basis of nationality only, even if it was one. Even if we only had one non-national policyholder and we gave it 100% of the non-national policyholders, there is still no discrimination on the basis of nationality only.
So the rationale then for the unequal treatment is not nationality, you're saying. It's something else.
Precisely.
Okay, but you must have heard of principles of proportionality and so on and so on. And this is where I'm going. I'm just wondering whether those kinds of principles can be used to discipline the notion of discrimination on the basis of nationality only.
With respect, I don't see how proportionality applies if the evidence is, or the facts show, that 100% of the non-national policyholders benefited. He may think the number
1 or 100.
Precisely, whether it's 1, 100, or 50,000 of the 52,000, 100% of the non-national policyholders benefited from the bailout. So no issue of proportionality comes in there. It's 100%.
Okay, I think we've heard you, Mr. Davenport. Is there anything that you wish to say in relation to whether the issue of the discrimination point and the issue of the Article 184(1)(j) point should be listed as preliminary points? I need to tell you that we have, and you should have gotten that intimation from the note that we sent out. We are firmly of the view that it is in the interest of economy and efficiency that we should table at least the Chapter 3 point for discrete, C-R-E-T-E, sorry, discrete legal argument. And I simply want your views as to whether that list of points that should be addressed in a discrete fashion should be enlarging to encompass, as the defendants suggest, the points about discrimination and Article 184(1)(j).
Thank you, Your Honour. Could I just address one or two small points? May I just start by saying I hope that Your Honours understand the basis upon which we were not pushing back, but were asking, really testing whether this court had fresh thoughts, having seen our skeleton argument and developing one or two small points. It wasn't, as it were, in any way disrespectful of what the court's intimation was in that note. We just knew that the note had arrived before the skeleton argument had set out our thoughts. So it wasn't that we were being truculent or in some way.
No. We instinctively recognize that the two notes had crossed, so there's nothing of the sort. Yeah.
I'm grateful. We don't have any observation apart from to agree with the formulation of, as it were, 1A, preliminary C1A that you have formulated. We are firmly against the idea of the two extra issues that have been formulated by my learned friends. It's not merely that the answer is de minimis. It's probably not relevant at all. It is most certainly factually based. There are even facts about the 13. These might be 13 anomalies, and we suspect probably are, that have fallen between the cracks. And those facts in relation to them are themselves going to be necessarily relevant to the argument that would be surrounding what my learned friend is trying to carve out, namely a sort of control exercise of limited factual input with some consequences that she wants to derive from it. And that's all very far removed from what should be a preliminary issue. The one thing we haven't mentioned today, but it's a statement, I think, of the obvious, I hope I wouldn't have to try too hard to persuade the court of this, is that preliminary issues are once and once only issues. So it would be very difficult in our respectful submission to see how those issues could best be disposed of without any factual context, because we could envisage quite easily a number of situations whereby the factual context would be all important, or might be all important. And in those circumstances, we can't see any safe benefit to having the preliminary issue raised. So that's really what I wanted to say. I mean, we're looking at the main effect of the factual actions which need to be determined by this court because they are hotly disputed. And we are talking not merely about jurisdictional issues in their B and C, but really substantive issues that go actually to whether or not, as a matter of fact, and as a matter of law, the state discriminated. And so much of what is in those points B and C is an interweaving of fact and law. And whilst I fully understand that in some instances one could carve out the legal element of it, leaving the facts alone, I don't think that's the best way of going forward. And I would see the risks of having to do the exercise twice, secondly in a factual context somewhere down the line. So those are our submissions in respect of the further preliminary issues that they have drafted for your honour's consideration. Sorry, I'm sorry.
I'm sorry, no, go forward, please.
No, I was going to say that there is a sort of overlap between preliminary issues and the scope of them and disclosure, because the annotation also arises under the disclosure paragraph, which I think is paragraph 5, and there is an assertion that it would be somehow a breach of confidentiality and therefore not permissible to have disclosure in respect of anything outside of the 13. And I would take great disagree with that. They cannot just sweepingly get to a confidential position or limit disclosure in such a way. They would have to set up that the confidentiality was relevant. It's not privilege, and therefore that confidentiality would have any type of effect and is not provided for in any of the provisions of any particular code. And so that would have to be dealt with. Now, what that shows us is that the limit of the facts is at large and is only controllable if she gets it her own way completely and is allowed to merely limit disclosure to those 13 people, as opposed to an obviously wider disclosure. So that's the concern. I think once one looks at the questions as interrelated, then it becomes more and more difficult to separate them out as preliminary once and once only issues. Your Honour.
Yes,
okay.
I wanted to ask two things. One is I still haven't gotten fully your response to the 184.1J issue and its relationship with non-discrimination. And I'd like to find out from you along the lines the President was exploring, whether this, in your view, is a standalone claim or if it is somehow interwoven with your claim for discrimination or claim on the basis of discrimination. So that's one. The other thing, though, I was sort of wondering about. I think I saw somewhere where you had proposed the 15th of July as a sort of terminal date for
31st of July. For
31st of July, yes.
Schedule, yeah.
But isn't there the possibility that there could be other claimants who come out of the woodwork, so to speak?
Absolutely. Absolutely.
Right. So are we not facing a situation of an indeterminate number of claimants? The dependent being liable for an indeterminate amount over an indeterminate period of time. And I'm just wondering, and this might not be worth anything at all. I'm just wondering whether, if we were to get there, and of course, given our discussions this morning, that's a big if, we were to get there, whether a global sum could be awarded from which the policyholders could draw down over time. And would this not be a better approach to take than the one of trying to find these individual policyholders? I think at the moment, last I saw was 538, and the number is increasing every day almost. And I know that this is an approach adopted more in American law, perhaps, but I'm just wondering, just to throw it out there, if that is not something which might be, in a sense, more efficient in the end than to have a situation where even after the end of July, people come forward, or even after the case is settled, people come forward. Is there a possibility of a global sum? That, of course, would, I presume, take into account the benefits that these policyholders would have received under their own national government regulations and so on. Just a thought.
No, these are very, very good opposite thoughts, Your Honour, and arise all around the world in various different jurisdictions under various different types of rules relating in different countries to group litigation or class claims. Just to put it into context, I'm told, I'll be corrected if I'm wrong rapidly, that we are something like 80% of the perceived universe of likely potential claimants at the moment. So it's already a substantial proportion. And in these sort of cases, it's almost inconceivable that you would ever get 100%, because some people just don't want to be bothered. Some people just somehow don't understand it, and various other different reasons. But we're not, as it were, at the stage, a bit like a Competition Act claim, and orders of which hardly ever get made, of opt-in or opt-out types of claims, whereby the court might make an order and you actually have to consciously opt out of any claim. So I don't think we're at that position. So we believe for the mechanism that has been constructed and the arrangements that have been reached contractually with the individual claimants, that this is the right way to go, and this is what this group is positing. And we're covering a very large amount of the group, and they still have the ability to join that group. So I think the better way of responding is we have tried to do our best to agree that there should be an end point, although I have to say I respectfully and instinctively agree with Your Honour, which is that it would be a great shame if there were people who are coming after any particular cut-off date, because they should be entitled to join in. And I suppose they could, because they could join, they could separate their own action, and that could be consolidated in due course. And the court has got the power to do that. So it's not sort of lost forever, if that was the case. But I think it's a perfectly decent position that we find ourselves in, either that there is no cut-off date, or at least not yet, because this is something that we could push down the line and the court could consider the matter further at some later date. Or alternatively, if we really owe some sort of obligation to the court to call time on it, then we thought that that was a reasonable period to get in and to verify the details of those people. So I'm very much persuadable that we should extend it. It was just that if the court felt that it was necessary, we felt that we could, with all good conscience, sign up to the 31st of July. I don't know if I can say more about that point at the moment, because some of the other aspects are actually the waters run deeper than just a surface discussion about these matters, and I need to take instructions about it. As to the discriminatory point, that's clear. There can be freestanding, i.e. not correlated to Article 7, discriminatory claim under Article 184. That's our position. And indeed, that applies to claim number 4, which is the same discriminatory restrictions in the regulatory scheme, with the result of excluding BA International from the supervision and intervention of the regulatory authorities and amounting to a breach of that Article 1841J, as set out in the originating application.
You would agree, though, that you would be confined by the terms of your pleadings?
Yes, I would always agree that, we are satisfied with how our pleadings have been pleaded, and we're not having to make a sort of ad hoc application to amend. But I respectfully agree with exactly what you just said. Yeah.
Thank you.
Thank you.
Yes, Mrs. Peake, we don't need to hear you just yet, if at all, on this issue of cutoff dates and the register of claimants. What we'll do is to take a short recess, and we'll come back to you shortly.
Much obliged.
Okay, are we all back? I think so. Mr. Davenport, just before I ask Mrs. Peak to make a few comments on the issue of the claimants and the cutoff date and the like, is it the case that now there are a definitive set of claimants, and then, as I understand it, and I want you to correct me if I'm wrong, we had allowed you to continue to unearth potential claimants, and that you wish to have that permission up until July the 31st, following which you're going to cease unearthing any more potential claimants, but that we have not yet determined, the court, how that list of potential claimants should be addressed, should be dealt with. Is that the case?
That is the case, Your Honour. That's the offer that was made in the skeleton argument.
Okay. Now, Mrs. Peak, what we are thinking is that we would allow that permission to unearth potential claimants to continue up until July the 31st, and then sometime after July the 31st, we would hear fulsomely from counsel argument on how the court should deal with this list of potential claimants. Do you have a difficulty with that?
I do have a difficulty with that, Your Honor, because of the uncertainty involved. But I wanted to draw to the court's attention Article 221 as construed in Myrie, which says judgments of the court shall constitute legally binding precedents for parties in proceedings before the court, unless revised and so on. And whether that would not capture any concern that Mr. Davenport may have that other parties similarly circumstanced should benefit in the event that they have an order in their favor. In other words, whether it is 538 or 10,000, if the court decides against us that this claim succeeds because the state of Trinidad and Tobago should have afforded to, it may turn out, all Caricom nationals the same benefits of the CLICO rescue plan that it did to nationals and the non-national policyholders, then it seems to us that by operation of Article 221 and how the court has construed it, that they would have the benefit of that judgment. In other words, it is not necessary to just keep on adding persons outside of the Grenada and Antigua list that are now before the court and who have obtained leave of this court to pursue the claim. So we would want to respectfully suggest that as an alternative to simply adding whether up to a cutoff date or not.
Yeah, but that is an argument that you could make when you are given an opportunity to make fulsome submissions on how this list should be treated.
Well, I would prefer to do the other way, that you have our position on it before you make an order, because I think what was circulated by the court yesterday was that the court would defer all issues relating to this register, whether by striking out names or adding potential claimants, so that the court could focus on the preliminary issues. And
yes,
I thought
and we
that
don't
was
want
a helpful.
We don't want to add any claimants now, but they have been at their own expense and on their own initiative unearthing potential claimants. And we are not minded to say to the claimants, stop that, but instead to give a determinative, a definite date when we say to them, no more, you can't do any more. But that is without prejudice to the court addressing the issue of how all of those potential claimants should be dealt with. It may be that we would say that, and the claimants are probably hoping that we say, okay, you just become claimants in this case. Or we may say, as you have suggested, that, well, listen, okay, you've done the hard work of unearthing these people. but there's no need to join them as claimants because 221 will apply to them, and therefore, there's no value to making them claimants. We have not made a decision on either one or the other as yet.
Your Honor, our position would be that we would prefer if the court not get involved in that process. In other words, if the claimants wish to continue their compilation up to a certain date or not, that's a matter for them. But at the stage when the claimants wish to engage the court as to whether any additional party should be added, then the court will have the benefit of submissions from both sides on that question. In other words, nothing stops my learned friends from compiling their register and adding names as they see fit. But I would prefer, with respect, that it not have the stamp of approval of the court until the court has the benefit of submissions on the advisability of going that route by way of a court order.
Okay. Of course. Okay. What we will do is to afford the parties sometime after July the 31st, and the order could say that in deference to you, that the parties will be afforded an opportunity to address how the list of potential claimants that has been compiled by the claimants should be treated. So that is one order that is going to be made today. The second order that will be made today is that the court has defined for preliminary discussion, preliminary argument, determination, the matter as listed in 1A of the defendant's submission. That is assuming, for the sake of argument, the truth of the matters pleaded by the claimants in the originating application, do the actions of the state of Trinidad and Tobago alleged by the claimants fall outside the scope of Chapter 3 of the RTC because they fall within the meaning of Article 32 and 33? If the answer to that question is yes, what are the consequences for these proceedings? We will defer for the time being the identification and determination of any other preliminary point. But it may well be that after we have concluded this point, we may wish to revisit that issue. But at the outset, we wish to have that first issue determined. And so the question is, let us start with an outside date and then work towards it. When are the parties able to hear that matter? I noticed that Mrs. Speaker, your side suggested, or was it the other side, November?
That is correct. We had suggested November. The court had proposed 2 dates in October, and regrettably, October is a very difficult month for us. So we were suggesting, subject to the court's convenience, and of course, my learned friends, a date in November.
Yes, Mr. Davenport.
I'm sorry, Mr. Strang and I were discussing this and got the wrong impression. And in fact, we thought that they were actively suggesting October the 10th and the 11th.
No, the court has suggested that, but Mrs. Peake suggested that they were unable to, that was not a convenient date for them.
Yeah, no, I understand that. Looking at my diary, if we're doing it on the hoof, I don't know which dates in November are available. I think it would help if we could find some specific dates.
Yeah, sure.
Yeah.
Maybe the week of the 7th.
No, I'm afraid to say I know I can't do that. I can't do between that week or the next week, unfortunately.
Okay.
I don't know if there's dates in October that are available. We could have done the 10th and the 11th, but November becomes more problematic.
Ms. Peak, are there other dates in October? The later in October, it is the court wouldn't be able to do late October. The court can do the week of the 10th apparently is out for Mrs. Peak. We can do the week of the 17th, but not the following week. Is the week of the 17th convenient to you?
No, that is problematic. We were going to suggest the last week, which the court has now indicated is not convenient, which is the week commencing the 24th. Yeah, and then next week, my learned friend says they're not available in the first 2 weeks. Or is it 3 weeks?
Well, no, I'm available in the first week. That any time from Monday the 31st of October is good. That week is good.
That week is also good for us, Your Honours. The week commencing the 31st of October, so we have 1st, 2nd to the 4th of November. Any of those dates.
Okay.
Yeah.
Yes. I think that is Justice Whitten, Justice Anderson. The Tuesday
and Wednesday, or Wednesday and Thursday.
Yeah. Okay.
Not a problem for me. So.
Yeah. Okay. So let us say Tuesday and Wednesday, 1st, 2nd November. All right. Now,
is it either one? I don't think we need 2 days.
Well, let us timetable the 2 just in case. Okay. But we should finish on the first day. Now, Mrs. Peak, you would go first because you are the one who are alleging.
We would have no difficulty with that, Your Honour. You mean by way of written submission and oral submissions? Yes, we can go first.
Yeah. Yes. When can you get in your written submissions?
Could you give us a date? Well, I'm not sure when the term of this court opens, but we're thinking a date around the 19th of September.
That strikes me as very late, I have to say. I mean, if they know that there's a knockout submission and they believe this strongly, why can't they do it by the end of July at the very, very latest?
Of course we can, but we also have a number of commitments, which is why I didn't want to add our July commitments. June and July are very busy months, and of course, doing it after that involves us doing it in the court vacation. We still have a court vacation here, as far as I'm aware.
Well, that's as long as it's not your vacation.
Sorry?
As long as it's not your vacation, that's fine.
Well, of course, we try as counsel to have our vacation coincide with the court vacation. That's the only way it could work. So that's why, I mean, whatever the court, if the court wants to shorten the time period, we will comply.
Yeah,
that was our respectful submission, suggestion. Sorry.
That date was too far, I think. Give us another date.
Would you say the 15th of August?
Okay, that sounds better. And when would you be able to do yours, Mr. Davenport?
But by the way, we observe very much the vacation as well, and August is squarely vacation. September has eroded over the years and is a bit more active. Would I don't know if the 15th of September is a natural date or a weekend, but would you, yes, 15th September is a Thursday.
It's a Thursday.
Yeah, would you say close of business on the 15th of September?
Yeah, okay. 15th September. And when you want to do a response, Ms. Peak?
Would you say the 14th of October?
That only gives the bench 2 weeks. Give me a date a little.
7th of September. Sorry, 7th of October.
7th of October. Okay. So the 15th of October for the defendants to submit, 15th of September for the claimants to respond, and then reply by the 7th of October.
Sorry, could you repeat the first date again, President?
The 15th August.
15th August, right?
Yes. 15th August, 15th September, 7th October. Now, this issue does not require any kind of disclosure.
No.
This is a straight issue of law. What else? On the issue of Caricom participation, I note the points that were raised by the defendant, I think it is.
Yes.
And that's fine. You wish to say anything on that, Mr. Davenport?
We were broadly supportive, but at the same time reasonably agnostic.
Yeah. Okay. And so that's fine. They have not said anything to us, and so we leave it at that.
But I suppose the point, though, is we might have to have a contingency in case they do say at some point they wish to say something. So I suppose the question for council would be, well, would you have any reaction to that contingency?
Yeah, I respectfully agree with Mr. Justice Anderson, and I think that rather than hoping that they just respond, having picked up on this hearing, maybe the right thing to do is to give them a period of time by which they can ask to join in one way or another. I know force it down the road of a amicus curiae, but in some way, in some participation, I think they should be asked by the parties jointly or by the court.
Yeah. Ms. Peak, you have any observation on this?
The only comment I make, Your Honor, is that I know that Caricom is concerned, and I know that through our representative on Caricom, about the costs that Caricom incurs in these proceedings, and they're not always able to recover them all. We recently had an order of this court which helpfully gave the state all its costs, but deprived Caricom of some of its. And I know that is a concern at the Caricom level, that when Caricom, and of course, if they are invited to attend, I'm sure they will feel under some kind of obligation to do attend, that it comes with attendant costs. So that would be my only concern. I would much prefer if Caricom was free to determine, whether it wished to participate in any form or fashion, rather than it being court-directed or even parties writing and asking them to indicate their position by a certain date, which again might have a kind of compulsive element to it. But
I'm so sorry.
No, I'm saying other than that, we entirely in the court's hands.
No, that was in fact the brunt of what I was trying to say. I was just trying to see whether there was any concerns or other interests on the part of counsel to a voluntary submission by Caricom. I wasn't suggesting that we necessarily invite Caricom to do anything. I just wondered if there was any issue there. And I gather there is none. If Caricom voluntarily decides to send something in, then you have no difficulty with that. Am I right?
Well, I think that is a departure from what is in the note that the court sent, because you specifically said as observers without requiring anything from them. So that's why we responded in kind that, there was no necessity to invite them to observe because, of course, they were served with the proceedings and it was open to them to observe. But I think what is now being suggested is some greater participation in the form of a note or a submission. And that was not how we understood it.
Yes, I'm sorry, Mrs. Speaker. I wasn't even suggesting we go back to the note. All I was interested in finding out is whether there was any difficulty, interest on the part of counsel in the eventuality that Caricom of its own volition, without any intimation from the court or from counsel, was to decide to send in submissions. That is all that I was asking about. I wasn't particularly going towards inviting Caricom to do anything.
But I think the court could. I think the court could give a date that on or before which they would have to indicate if they wish to submit something to the court. At least that you know that something is coming or not.
Might I suggest to assist that this started with a draft note which says, subject to first hearing the views of the parties, the court proposes to invite Caricom to participate. Maybe that, as Mr. Justice Witt says, a date in short order can be decided upon for them to make any representations about whether or not they want to participate in any way, but make it explicitly clear that there is no obligation or expectation that they have to do so.
Yes, and yeah. I rather like that formulation, and the court will respectfully adopt it. It's not that we are requiring them to participate or expecting that they would participate, but that if they wish to participate or if they wish to in any way take a more visible take more visible interest in the proceedings, then we will certainly accommodate that.
And they must do so by a particular date.
And they must do so by a particular date, yes. Okay, is there anything?
What date would that be? I think we should decide what date that should be so that if they did, counsel could respond.
Right. I would think maybe we can say the same, the 31st of July, the end of July, so that it will be before the first set of submissions are made.
Yes, that would be appropriate, Your Honor.
Yeah.
Yes.
Agreed.
Okay. Now, there are various aspects of disclosure which have been mooted. There are two ways we could deal with that. We can say, well, okay, that can continue in the background in the meantime, or we can say, let us hold up on that until we dispose of the first preliminary issue. Do the parties have any views on this? Mr. Davenport? Sorry, you go ahead, Ms. Peak.
We would certainly incline to the latter of the views expressed by you, Mr. President, that we are now focused on the preliminary issue in which the court has decided there's no disclosure required. And I think our attention should be focused on that. After the preliminary issue is determined, then that will inform the breadth of the disclosure that will be required as we understand it. So we respectfully invite the court to defer giving any directions as to disclosure until we have resolved the preliminary issue.
I agree.
Yeah. Wonderful. Okay. Is there anything else that we can conveniently address today?
No, I don't think so. Thank you very much.
Nothing further from the defendant, Your Honors.
Okay, so we've agreed. The court would order, but first of all, on the issue, there's a little bit of grayness there. On the issue of these additional claimants, the claimants are free to proceed as they have been proceeding. I know this speaks antipathy towards the court saying anything in an order that addresses that issue. And there is no need for the court to do that. But we can say in our order that the court shall, at a time to be determined, address the issue of the list of potential claimants that has been compiled by counsel for the claimants. And secondly, the court will hear argument on a preliminary point as we have defined, and the timetable is that the defendant will submit on that point on or before the 15th of August. We haven't alluded to the length of submissions. Now, our court doesn't like unwieldy and prolix submissions. We tend to confine counsel. This is a very important case, and we don't want to deprive counsel of a full opportunity to give their arguments. Ms. Peak, at this point, do you have any idea as to how long you would be in terms of pages, or is that an invidious question?
That is a very difficult question, but I would not anticipate more than 20. But I hope the court doesn't hold us to that. But we do accept that it's not very helpful to produce a very lengthy, wordy submissions on a point of jurisdiction such as this, and we will do our best to keep it as short as possible.
Okay, Mr. Davenport, we don't want to restrict you, but at the same time, you know, we don't want lengthy quotations from cases, for example, you know. And while we are not a paper-based court, nevertheless, for us and our judicial counsel to have to wade through, you know, 30, 40, 50, 60, 70 pages of stuff when 20 could suffice, you know, we much prefer that. So we won't put a page limit, but we will expect and anticipate that counsel would be responsible and efficient. So the defendant will submit by 15th August. The claimants will respond by 15th September, and the defendants will reply by 7th of October. And we will hear this matter. Now, do the parties have any views as to whether they wish to hear this matter in person in Port of Spain, or whether they wish to hear this matter in this format?
I don't at the moment, but I anticipate that we might have a view. Would it be acceptable to communicate to the court within, say, 7 days of what our preference would be, and maybe very short reasons why in a letter?
Yes, sure. Of course, we would just, you know, receive and consider your request. We won't be bound by it, but it would be good to hear what your views are. Ms. Peak, do you have a view at this time?
Your Honors, we can say straight away our preference is to do it in this forum. We've been able to manage cases in this way very, very efficiently, even including cross-examination of witnesses. So we see no reason why short oral submissions cannot be handled cost effectively in this way, particularly because my learned friends come from a number of different jurisdictions, and I'm sure it would be far more convenient for them to do it in this way than for us. we would certainly see this as the way to proceed once the court agrees.
Okay. Well, if you have a change of mind or you wish to indicate, then you can do so. I would say before October 7th, so that we would know if we are gearing for an in-person or a virtual hearing.
Thank you, Ronald. We will very much try and give you the answer sooner rather than later.
Yes. And I think that brings us to the end of our proceedings. We'll have the order drawn up and sent to you in due course. I thank you very much for your participation here today.
Your Honor, just before you close, yeah. I wonder if it would not be helpful to give an indication as to how long the oral submissions ought to be. Because I think that would guide us. For our part, we don't envisage it should be more than an hour on either side, which might be generous, but we're entirely in the court's hands. And I think it would assist us in preparing for that date in November, if we know how long the court expects us to address them for.
Mr. Davenport, do you have a view as to how long you will likely be?
I tend to agree with my learned friend. I think it's more likely determinable by the questions that your honours put to us and how we deal with those questions, hopefully succinctly and to the point. But I would hope that if we all have an understanding that, roughly speaking, we have an hour each, without being perhaps guillotining it at an hour, then we should be able to manage it.
Okay, so that seems fine to us as well. And about 15 minutes for the reply. So we will cater for 2¼ hours. But of course, if there are a lot of questions, as you said, we wouldn't just bring down the guillotine at an hour, as the case may be. Okay, so thank you very much, Council. I think this has been productive. And as I said, you will get the formal order of the court in due course.
Very obliged.
Madam Deputy Registrar, you can close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Council. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.